Wait only 10 more seconds.
Yeah.
Yes, ma'am.
If I can mention a issue that we may have during our motion, I was talking with IT this morning about playing my evidence. But there may be an issue with being able to play it with the Zoom being hooked up, so I just wanted to have a discussion with you with IT, so we can try to figure out how.
Sure. So when Mr. Dunham is out here, if we need to turn Zoom off, at least the big one, and just operate it from here, that's fine with me. The important part will be playing the evidence. And my recollection is there's body cam video. And if that's important to the dispute between you and Mr. Franklin, we're going to need to be able to play it. So I don't know the cleanest way to pivot from one to the other, meaning how to, I don't have to turn that off. Then I guess we would just be using the evidence presentation system. Press that thing, the magic button. Okay. And you know how to log on to that?
No, so I came early to do that, but then when you said, I was told we couldn't do it, I just didn't try it at all.
Okay.
So I haven't attempted to play it because I think he was mentioning how we could play on your personal video kind of things. I didn't know if that's what we were going to go with, because I guess that's happening in other courtrooms. So I didn't attempt to play it yet because I didn't know what resolution we were going to come up.
Sure. I think if we were working with a defendant and or an attorney who were appearing remotely, we would have a problem. But Mr. Dunham is here, Mr. Franklin is here. So I'm less worried about the clear touch system. So I can find out. Ms. Hansberry knows how to log into that thing. Well, it looks like we're getting in. I don't know what will happen though when it times out. I think there's a way for it to be. You said not the timeout. Great. I don't think so. I think we'll have the witness just pivot and look at the big screen.
It's at 11, we don't have to stop our current calendar.
No, that's okay, but that way we don't need to have IT come on back if they're able to get in. So let me just ask for organizational purposes. Position 1, Gregory Gordon, who's handling that for the defense? Mr. Franklin, all right. And Ms. Patel has position 2. Position 3 is another old revocation of Terrence Bates, also Mr. Franklin. And Ms. Young is on the call and ready to go.
Good morning, Your Honor.
Morning. Ms. Brown, get that wonderful bond, thanks to Women on the Rise. And then Ms. Snyder has one case. And that's it for the inquiry, and then we have at 11, but we can start sooner if we've got everyone we need. The motion to suppress statements and Mr. Dunn. I think that's what we've got. So let's figure out if we can get in there. I think if you switch it to McBurney, we can get in. Ms. Nelson, can you check with Ms. Hansberry about what the password is to get into the computer in the courtroom? I think it's just McBurney.
Okay, I'll double check, Judge.
Thanks. But it wouldn't be under administrator, I don't think. Well, certainly not is.
Well, I might be able to.
Rest in peace.
Did Judge Hicks die?
No, no, no.
I was like, what? Oh my God,
It's just that we've been here forever. And sort of get them out the door.
I was living my big apple alone here.
I
He's hopefully doing very well.
Right.
Oh, you're in? How'd you get in? Oh, all right. Well, go check it. Yeah.
Are you good to go, Judge, or do you need Michelle still?
Good to go. We are traveling under Judge Hicks's secret codes. Don't tell him. If you see him. We're good. Thank you, sir. Appreciate it. I've got your number. We've got an issue.
All right.
Thanks. I don't actually have it, but we'll find it. All right, sorry for the delay. We are all set for, I think, both calendars this morning. So let's get started. I'm happy going through the calendar in the order it was published, unless Ms. Hall, I think they're all your cases. You have been talking with the lawyers and you want to handle them in a different way. All the inmates are here, so we can do it however you want.
I don't mind whether how we do it. Position 4 is the major case, that's not fine, but we can go in whichever order.
Okay, well, once we get someone from major cases planning on being here, or Mr. Pinion is gonna dial in, I guess we'll figure that out, because we do have Ms. Young, so, oh yeah, look at that, that would be a major case.
I reach out to him.
Okay, yeah, and once we see him online, then we can take care of Ms. Young and Mr. Pinion. And Mr. Hinton is one of the gentlemen back there? Okay, great. Guess we're just figuring out what we're gonna do next with this one. There was a Supreme Court ruling and go from there. All right, well, let's just go in the order of the calendar, unless the defense attorneys, do you have a preference, Mr. Franklin or Ms. Patel?
There you go.
Okay,
I don't know.
let's bring Mr. Gordon out, please. And Ms. Hall, if you see investigator Vance Williams, I don't know that I'll necessarily recognize, this is for investigator Vance Williams. He's supposed to come by and pick it up, I think. You wanted it yesterday, you weren't able to connect. Oh, Gregory Gordon, we talked about. This is one, he doesn't need to come, well, he can come out if you want.
I explained to him what was going on yesterday.
Okay, I'll explain to him too. We'll get to hear it twice. I'm sorry, only when I read the petition did I remember what happened.
I didn't even come on, it was new discovery.
Okay. Hey, Mr. Gordon.
How you doing, sir?
I'm doing well. You're welcome to take a seat. This is going to be pretty quick because I think Mr. Franklin has already told you what's going on. You have an older case. It was a drug case from 2018 for which you got some probation. And while you're on probation, it is alleged that you got in some mix-up with the police. There's an allegation that you committed an aggravated assault on a peace officer, you had a gun, etc. We're not going to talk about the substance of those charges right now. Those charges have not been indicted. No one is getting indicted these days. And what I've heard both from the prosecutor with Ms. Hall sitting over there and your lawyer, Mr. Franklin, is that these new charges are kind of complicated, and their preference, the lawyer's preference, was rather than work through a revocation hearing where we'll call in lots of witnesses, let's wait until you get indicted on these new charges and then see if there is a way to resolve the revocation and the new charges. And I got some email traffic from the lawyers and told them that's fine. We can always, if it's taking too long to get these new charges indicted, come back to talk about the revocation. You're going to stay in custody until we resolve things. There's not a bond for this revocation petition. But if for some reason the grand jury that starts in just a few weeks doesn't indict you soon, then we can always come back and talk about it. But we'll sort out what's going to happen. Mr. Franklin, I trust you've explained to Mr. Gordon that it's more likely than not that the new charges will be assigned to a different judge. I'm happy to have the revocation follow. They don't need to stay separate. I don't know that I'll ask for the new charges to come here, but if there is a negotiated resolution, I am happy to resolve them together.
If we're able to get to that point, we'll certainly reach out to you.
Okay.
Based on, essentially there was one set of discovery that was kind of put into the computers, but there was kind of another set of reports that I didn't realize until some point in time last week. Ms. Hall found them, and I guess we referenced with another defendant. And when I read that, I realized there were other things that may be helpful to our version of events. I explained it to Mr. Gordon. And additionally, one of the reasons I was okay with putting off the revocation is because even had we won the revocation, he would still be held in a no bond status.
Because of the new charges.
Of the actual new charges.
Okay.
So we're not holding him in just for the revocation.
Okay.
If we're able to get the discovery and I'm able to say, hey, this is clearly something in our favor, I'll reach out right away.
Sure, and then it may be an accusable situation, and who knows? So, all right. So, Mr. Gordon, I just wanted to tell you that directly. Mr. Franklin, obviously, is your point person on this. He's your lawyer for the revocation. He may not end up being your lawyer for the new charges if and when they get indicted. If that's assigned to another judge, that doesn't mean he forgets about you or ignores you. He'll help connect you and everything you and he have been talking about with the public defender in that other courtroom. Does that make sense? You have any questions for me? Okay, I know your main question is when, and we're working on that. Like I said, we actually are getting grand jurors back in the building. I think it's next week, if not, it's the week after. It's either the first or second week of November, so that we can start getting indictments of cases like yours where someone's been stuck in jail with no bond, waiting for charges to be brought. Okay? All right. Thank you, Mr. Franklin. Thank you, Ms. Hall. So, Ms. Nelson, so we don't forget about this, why don't we further notice this 60 days to an inquiry calendar?
Okay.
Thank you. That way it doesn't fall off our map.
Your Honor, I will be making an announcement for Lady Day.
Oh, okay. Well, why don't we do that? Should we bring Mr. Hinton out now because we've got Ms. Young? Hey, Ms. Young, we're gonna bring Mr. Hinton out now.
Thank you, Your Honor.
Bet. So for Mr. Carter, Ms. Patel, all we're doing is figuring out the lawyer situation.
Correct.
Okay. We'll bring him out after Mr. Hinton. Good morning, Mr. Hinton.
Good morning.
How you doing?
I'm doing good.
I'm Judge McBurney. Your lawyer, Ms. Young, is on the screen there. I'm gonna try a feature that will do speaker view. Ms. Young, can you say good morning to Mr. Hinton?
Good morning, Mr. Hinton.
You know,
Oh, it's actually that screen that needs to be speaker view, not mine. Never mind. You can see Ms. Young. Great. We just need to get a status update on your case, Mr. Hinton. You received a favorable decision from the Supreme Court. You may recall that there was a motion to suppress that your lawyer filed. Ms. Young, were you the lawyer who litigated the motion to suppress?
Yes, Your Honor, in front of Judge Reeder.
All right.
And I sent Mr. Hinton a copy of the opinion once it came out. So he didn't get advance notice of today, but he does know about the opinion and what it means.
Great. So you and Ms. Young have talked about it. She was successful. She got Judge Reeder to suppress some statement you gave to law enforcement. The state appealed that. The state lost on appeal. So the Supreme Court has said, if there's a trial in your case, what you said to Detective Young at the police station is not something that the state can use in its case in chief. So that's where we are. And the reason why I brought you over here was to figure out what can we do to move your case along. It's not a new case. And it's actually it's a peculiar case because you had, I think, 4 or 5 indictments, and then they all got mashed into one. So at another time, I suspect Ms. Young and the prosecutor and you and I are going to talk about if there's a trial, is it just of the murder or is it of all these different things and how are they connected? That's not what we're going to work through today. I'm going to get an update from the state. I'll get an update from your lawyer, and hopefully we'll have a plan for what we can do next in your case, okay? All right, so Ms. Hall, I know you are not the one who's necessarily handling the prosecution of Mr. Hinton, but you have an update from the major case unit.
Yes, yes, Your Honor, the update is that all discovery has been served, the date is ready for trial, and it takes about 2 weeks for trial.
Okay. Ms. Young, were you able to hear that?
No, Your Honor, I'm sorry. She was muffled.
That's okay. Our sound system is not perfect here. The announcement that Ms. Hall received from her colleague is that he, Mr. Pinion, believes that all discovery has been served, the state is ready for trial, and the state believes that this case would take about 2 weeks to try. I'm assuming because it is 5 indictments rolled into one. Did you hear what I said?
Yes, Your Honor, clear. Thank you.
Great. I would like your sense, Ms. Young, as to how complete discovery is.
Your Honor, most of the discovery has been satisfied. I've not heard from anyone from the state except in terms of receiving briefs, since the last time we were in court, I believe, which was about a year ago. So I don't know who's currently assigned. It was Miss Love who was assigned. The second issue, Your Honor, is there are numerous motions that were not heard because of the appeal. And in terms of case management, I would respectfully suggest that the motions be set down prior, not at the time of trial, but separately. Without going into too much detail, there was an issue about discovery when there were representations made, and I have some follow-up on that. I don't know if that gives the court enough of an announcement from the defense, but that's what we would be requesting. Additionally, there were 2 statements that were the subject of the Jackson Deno, which was granted. I'd like an opportunity to speak with the prosecutor about how that impacts their case. I understand their position is they're ready. However, one of the motions that's pending is to set aside the null pros and go back to the 5 cases.
Okay, I did hear you. Let me press you a little bit though on discovery. Your belief is that you've got everything. In other words, you're not aware of a police report that refers to a witness interview and you don't have that witness interview.
In terms of the reports, Your Honor, some of the videos we were unable to access, and when I looked at the transcript of the hearing yesterday, that was mentioned. There are usually codexes which accompany those videos, and if they, in this case, they did not, I was not able to open them, but I'm more than willing to go to the prosecutor's office and watch them, which is customarily what I understand happens, and my customary practice as well. There were several confidential informants. We don't have the information about them. That's still a motion that's pending. We'd requested that the court order NCICs be provided. The representation in court last year was that I could go through GBI. From having been a prosecutor in DeKalb and a defense attorney in Atlanta for going on 12 years now, that's not my understanding. But I went ahead and sent an email to the GBI saying, hi, is there a practice where I can get NCICs for witnesses? And the response in writing, which I'll be happy to forward to the court and the prosecutor if requested, indicated, no, you have to contact the FBI, which was my understanding, but the FBI won't talk to me. Conversely, all that the prosecutor's office has to do is make a request through investigations unit to run NCICs on certain witnesses, and then they'll provide it. They were reluctant last year to run those and said on the record, well, if we run them, we'll give them to you, but we're not looking to run them. And that seriously compromises my ability to be able to prepare for the case.
Is it your belief, Ms. Young, that there are material witnesses in this case who have criminal histories outside of Georgia?
Your Honor, because there's no depositions in Georgia, unlike Florida, where I came from initially, there's no way for me to determine that. However, I think this is my 11th homicide defense in the last 10 years. And very often there are criminal histories and convictions out of state that I can then obtain once that's provided. So unfortunately, there's no way for me to know, given the discovery laws in Georgia, as to whether they do or they don't. So it's only in homicide cases that I do make this request, because I believe that to do so otherwise would not be appropriate on my part, because there's so much at stake. I think it's appropriate to ask. And the case law that I provided last year to the court, which I believe was, I'd have to look at the site. I think it was the Davis case.
Well, we'll revisit that. I don't mean to put you on the spot now. I just asked because I don't know the facts and circumstances of these cases, but oftentimes we are dealing with young men who grew up in the same neighborhood, and that neighborhood is in Fulton County. CIC is a little bit of overkill because I know you can't depose folks, but the answer is I've never left the state of Georgia. But we'll explore all that. It sounds like what we need to do is have a brief case management hearing, which we may do telephonically, so that we can figure out what motions still need to be heard. And then we can set a date when we could get Mr. Hinton back in court, and you'll be able to decide whether you come to court or appear remotely. Let me ask Ms. Hall a question. It's a major case, but it has gang allegations. Is this Mr. Pinion or Ms. Convery? Whose case is this? Mr. Pinion. Okay. So Ms. Young, your counterpart is Brett Pinion. That's who you'll want to talk to in terms of, and I'd ask you to do so before we have a case management conference, about discovery and playing those interviews or whatever videos you weren't able to access. He's generally very responsive, but that's the lawyer. It's no longer Ms. Love. Depending on how elections go in a week, she may be the elected district attorney somewhere in South Georgia. But it's Mr. Pinion.
Thank you, Your Honor. Mr. Pinion was on the case several years ago. As the court knows, my client's been in custody for over 4 years now. So I believe he would have been at that time familiar with the case. And
Okay, well, we will make sure that this moves as quickly as is safe for your client's rights. I didn't know this case was as old as it was. Well, I know how old it is because there are 16 SC cases. I didn't know that your client had not been out since then. Since there was a 17 SC case, sometimes that means someone got out and then there are new charges the following year. Either way, we need to make progress on these. So if you would reach out to Mr. Pinion, and then Ms. Nelson will reach out to the two of you to set up a time when we can talk just telephonically about scheduling, and we'll get a date to get Mr. Hinton back in here and we can work through the other motions. Are any of the other motions evidentiary, Ms. Young, or are they ones where it's important that we discuss them, but no one needs to call any witnesses?
some of them are evidentiary, Your Honor, and I will be, if the court permits, appearing live for any evidentiary motions or hearings.
What's an example of an evidentiary motion that hasn't been heard? Is it the second Jackson Deno piece?
The motion to disclose a confidential informant is typically done live with the officer and the handler in the courtroom, subject to cross-examination. There's a motion to suppress and dismiss, which is pending. Those would be evidentiary, Your Honor.
Okay. All right. We'll reach out to Mr. Pinion, and then Ms. Nelson will connect with the two of you, and we'll figure out how many motions are left and what we need to do to work through them. Okay?
Yes, Your Honor. Thank you very much. I appreciate the opportunity to appear via Zoom today.
You're welcome. Mr. Hinton, you and Ms. Young will talk. Do you have any questions of me, not substantively, but just sort of what's going on with your case? Okay, other than when can we get this moving? Okay, well, that's what we're going to try to do. When I have this phone call with your lawyer and the prosecutor, you won't be on the call because we won't be talking about substance. There won't be any argument. It's just going to be, tell me how many motions, how much time do you need, and we're going to find a day when, or however much time we need, maybe 2 days, to get you and Ms. Young back in here so that we can work through those motions. If we're going to talk about your case substantively, about evidence or anything like that, you will either be here in person or it'll be one of these Zoom calls and you'll be on that. Okay? All right. Thank you. Ms. Hall, you let Mr. Pinion know that Ms. Young will be reaching out to him, and then Ms. Nelson will be wanting to schedule a conference. Thanks.
Thank you, Your Honor. May I be excused? That concludes my business.
Yes, ma'am. Thank you.
Thank you, Judge.
So let's do Mr. Carter, please. Mr. Carter's here.
Yes, this position too.
Great. Hey, Mr. Carter. We need to get an update from you about lawyer. When we last talked, it was a month and 5 days ago. You had mentioned that you or your family or folks close to you were going to line up private counsel. Does that happen?
I'm not sure which one you're gonna go with, but they did contact the lawyer, but I just wasn't able to really get in contact.
Okay. When you say in contact with them, meaning with your family or with the lawyer?
with them.
Who's them? Family. Okay. When did you last talk to family?
2 weeks ago.
Oh, you haven't had contact with them for several weeks. Okay. Is there a number that my litigation manager could call for family to see what the situation is? Because if family tells, and who are we talking about? Is it mom, a brother, both? Okay, what's the best, most reliable number and person for us to call?
803
803
636 9191.
803 636 9191. And who's at the end of that line?
Patrick Carter.
Patrick Carter?
Yeah,
And that's that's your brother?
one of the lawyers that they did contact, I did talk to him. It was Scott Forte. He came down here like, I think, I want to say Labor Day or something like that. And he came out to his office there and met, but I'm not sure quite like what they discussed as far as the payment of the lawyer. So I didn't know if he was gonna go with him or another lawyer. They said they was looking to, but he did come down here and meet Scott Fortes. And I talked to him also that day, but I don't know what happened.
Okay. So if my litigation manager calls Patrick Carter, he should know something about what's going on. And if your brother and your family have decided there's just no way we can afford it, would they tell the litigation manager that?
Yeah, but I think it was just more so, I think it was trying to see which one it was gonna go with. I'm not sure, but I did talk to Scott Fortes.
Okay.
Like, I said 3 weeks to the month, was like around the same time I'm talking to you.
Okay. Well, I just want to make sure there hasn't been any activity that we didn't know about. Let's see, calling up the case here. No. So there was, you filed a motion, okay. But that's it. So we're stuck in this loop. I know you're anxious, and you're the one who will hopefully be applying pressure to your family saying, what are we going to do? Ms. Patel remains your lawyer until we can figure out who is going to take over that responsibility from her. But she's not doing her job by not moving your case along. You said you want a different lawyer. So that puts Ms. Patel in a tricky spot. So she's really not in a position to say, let's do this with the case. She's merely making sure there's a lawyer sitting by you when we talk about your case. So we'll reach out to your brother. If he says it's going to be 6 more months, I guess we'll encourage him to try to contact you so you can think through what you want to do. But we do want to try to keep your case moving along, okay?
Yes.
If You're pretty sure this number will be in service, or do you want to give me a second number to call?
That was the second number, I just got the number recently.
Okay, the 9191.
The 636 911, because I was trying to contact him on the other number. And a friend of mine said that he didn't have the same number, so I ain't gonna get 911. I just got that number.
Okay, well, I'll tell you what, we're gonna try to reach, your brother, Patrick Carter. If for some reason that doesn't work, we'll get you back here in the next few weeks to say, you know, really not our job to find the family. And so you and Ms. Patel can talk in a little bit. We're gonna get through a few other positions on the calendar. They won't take it away. And you guys can talk, okay? All right. Mr. Bates is next. Are you Mr. Bates? Good morning, Mr. Bates. I'm Judge McBurney. I've got a petition to revoke your probation that alleges that while you were on probation for a pretty old case, 2015 case, burglary case that you had with a couple co-defendants, that you caught some new charges. You were arrested in June of this year for criminal damage to property in the second degree. You got released, so you were in and out, but then you didn't report to probation, let them know you had gotten arrested. And then you're a little bit behind on, excuse me, restitution. That's less concerning to me. These may be difficult times to be earning money and less paying restitution. But the arrest is a cause for concern, and then you didn't talk to probation about that. So they asked for a warrant, I signed it, and we're going to talk today about what we might do with that. Mr. Franklin, what is Mr. Bates's intention today?
I believe we have a resolution to resolve today. Ms. Hall and I have spoken about the case. We will admit to the allegations. I will note that I do believe he would have been in custody at the point in time that he missed his probation report date. But it's not a huge deal, because the agreement will be continued, Mr. Bates on probation.
Okay. I mean, the petition simply says arrested on the 20th, released on the 23rd. So he was in for 3 or 4 days. And the allegation is he didn't report the arrest to probation, but not that he failed to report, as in, I've absconded. It's not an abscond, it's a, I didn't tell you, Ashley Lattimore, that was his officer. Oh, by the way, I got arrested and spent 3 days.
Understood.
Okay, so Mr. Bates is admitting to the allegations. It's a negotiated resolution. Why don't you tell me a little bit about Mr. Bates and what the negotiated resolution is? I'll hear from Ms. Hall and from Mr. Bates if there's anything he wants to add.
We got to the point of the resolution that involved an ex-girlfriend damaged the window of a car. Before we even got to this point, my understanding from him is that he's made restitution and paid for the window already.
So this would be a separate stream of restitution in connection with the June arrest.
Correct.
Okay.
My intent is upon his release, he should have his phone where he cashed after the screenshot showing that the money was sent to the young lady. And I believe he also says he has a letter that she signed acknowledging the payment. And essentially at that point in time, I will engage in further discussion with Ms. Hall to ensure that the case doesn't go any further. Kind of like a front-ended
Sure.
virtual PTI, just so it doesn't.
Because that's just, that CP matter is lingering out there.
Yes.
Okay.
He was working, and he still has the ability to get his job back at this point in time. And I'm sorry, he told me yesterday what he was working with. I told him, yeah.
City maintenance, manager, Sterling Accountability, property management,
Where?
Sterling at County Village.
Oh, Sterling at what village?
County Village,
Where's that?
it's on County Road, it's a senior community.
Okay. And property manager, meaning what are your responsibilities?
Not so much property manager, but facility maintenance manager.
Got it. Do you have a crew that works for you?
I got one guy underneath me.
Okay.
He's the one taking over right now.
How long have you been in custody?
About a month and a half.
Can you go back?
Yeah, they're waiting on me.
Okay, so the gentleman who worked for you or with you, he's having to do everything.
And both of them,
He would like you to be back.
he's going on vacation when I get back.
He's earned it.
Yeah.
Okay. All right, and your employer is aware that you have not been on vacation, but that you've been in jail, and they're willing to take you back. Okay, how long have you worked there? Okay. Where do you stay?
I stayed, I want to say West Atlanta, I stayed not too far from Front Street. I stayed out in Josephine Boulevard, house on Central Street.
Okay, and is that a house where you rent a room or it's your house?
I'm in a room, but it's with my godmother, it's with them.
Okay, so they'll take you back. Got it. All right. And the young lady whose car window you damaged, is she someone you still talk to, or you've gone your separate ways?
Several times.
Okay, but you've got something in your phone that'll show you
Most
took.
definitely, yeah, receipt, cash out. And prior to the arrest in June, I had her, like, basically, get that I paid for the damages.
Oh, so you didn't get arrested right when it happened. She took out a complaint.
Yeah, it was a warrant.
Okay, all right. How about restitution on the old case, the burglary?
I wanna try to go ahead and get that out the way, honestly. I said it's not that much.
$401.
I wanna go ahead and get that out the way.
That would be a good thing to do. Then you can, once restitution is done, probation can become non-reporting or even suspended, but they won't do it as long as there's some restitution. So let me find out. Good morning, Ms. Crawford. How are you doing?
Good morning, Judge. I'm fine. How are you?
All right. How much time remains in Mr. Bates's case?
Mr. Bate has five months and days remaining.
Can you say that one more time?
5 months, 2 days.
Okay. You don't have much probation left. But it would be good if during those 5 months and 2 days, you paid down a little bit of that restitution. In fact, I'm willing to say if you can provide proof of payment, once I see that, I can suspend the balance, but it's sort of going to be a race to the finish. You only have 5 months left. Ms. Hall, as I understand it, you agree with the recommendation that would basically get Mr. Bates out now, so we can figure out how we pronounce it, whether it's revoke 30 days, credit for time served, or who knows what, but it would be to get Mr. Bates out. Anything else?
No, Your Honor, I did try to reach out to the victim in the new case to see if she wanted some type of no contact in this, but I didn't get a response, so there's nothing at this time.
Okay. All right. Mr. Franklin, anything else on behalf of Mr. Bates?
No, sir. I will acknowledge he's on first offender. I want to make sure it's probably understanding that he will be continued on his first offender, meaning that he's been on probation for this long without any real issues. And those things that he did create as an issue, he was proactive in addressing the harmful part of it.
Okay. Any objection, Ms. Hall, to keeping Mr. Bates on first offender probation?
No objection, Your Honor.
Okay, you're almost there, Mr. Bates. Having the clean criminal history is going to be helpful as you advance yourself in the area where you work. Whether it's getting to be a more senior manager, going to another facility, if they run your history or you have to check the felony box, you go to the back of the line. So let's make sure you close out this sentence on a high note and stay away from the young lady whose car. How did you damage her window? You threw a rock. Was she in the car when you threw the rock? Okay. All right. Do you have any questions about anything? Ms. Crawford, if I revoke 30 days, but give Mr. Bates credit for time served, does that mean that he then has 4 months and 2 days left because I revoked 30 days, or would he still have 5 months left? Does that make
Still
sense?
want to have 5 months, still 5 months left.
Okay. And why would revoking him for 30 days not take away a month of the 5 months?
I think if you're going to revoke it and give him credit for time served,
Yeah.
so that means that he won't have to serve 30 days in jail, but he'll still have the 5 months of probation.
Okay, that's what I want to have happen. I just wanted to make sure we were maintaining the 5 months and 2 days so he has a chance to pay more of this restitution.
Yes, that's correct.
Do you need any contact information from Mr. Bates?
Yes, Judge, I need to make sure I have his contact information and then give him the report. And he's still going to report, but I need to give him a day to report.
Okay, well, let me do the part I need to do. So, Mr. Bates, you've admitted to conduct that constitutes a violation of the terms of your probation. You got arrested, didn't report that to probation. Those kinds of things are violations. You're behind on restitution. So what I'm going to do as a result of those violations, in particular the arrest, is revoke 30 days of your probation, but I'll give you credit for time served. So you should get out today or tomorrow. If you are still in late tomorrow, reach out to Mr. Franklin so we can figure out how to get you out. And I'm reinstating you on probation. I'm going to waive your supervision fees for the next 2 months so you can focus on paying the restitution. And if you pay down the restitution, you don't need to worry about the supervision fees because I'll suspend your probation if you pay off all the restitution. Did you have a question?
So I normally do my payments through JPay, and it doesn't give you an option to kind of separate the supervision fees and the restitution. So we making, let's say, $100 payment, it automatically separates it. So that's why I really feel like I'm really behind, because it's giving it to a portion that I'm really not trying to contribute to. You see what I mean?
Yeah, so if you pay 100 and your supervision fees are 50, 50 go there, which they're supposed to. But what I'm doing is waiving your supervision fees for the first 2 months. So if you put in $50, all 50 would go to restitution. Okay? All right. Ms. Crawford, do you need anything more from me, or are you ready to talk to Mr. Bates?
That's it from you, Judge. I just need to see Mr. Bates. Do you still have the same address of 871 Spencer Street?
Correct.
Yes.
Okay, and you're still going to report to Fulton County DCS. I'll just give you 48 hours after you release. You need to report to probation.
You know where to go on Memorial Drive? Correct. So if you get out tomorrow, you got to get there by Friday, okay? Any questions about anything? Mr. Franklin, anything else?
Nothing probably.
Ms. Hall?
That's a part of them.
All right, Mr. Bates, good luck getting back to that good job. That gets us to Ms. Brown, who I don't think is in custody. She shouldn't be in custody because women on the rise sprung her. So, Ms. Nelson, is this a notice calendar for Ms. Brown?
It is, Judge.
Okay. I know we were close to sorting things out with Ms. Brown, or maybe we weren't because of the ex parte motion. I don't remember the results of that. Well, my recollection of the results was that Ms. Brown was gonna, we were looking for a program to help Ms. Brown. No?
No, Your Honor, she was found incompetent and was waiting until they were regional for restoration.
Okay,
And then women on right.
got it. So, you haven't had any contact with her since she got out?
No, Your Honor.
All right. Ms. Hall, anything in connection with Ms. Brown?
Nothing from state, Your Honor.
All right, so I'm gonna issue a bench warrant in both the cases. And I'll talk with Ms. Nelson about whether we're gonna reach out to Women on the Rise, to let them know of the situation. But where we left it, Ms. Patel, is that I had signed the paperwork to get Ms. Brown to Georgia Regional. She hadn't been transported.
Correct.
Okay.
And Your Honor, I would just request if there was a way in order to reflect the fact that, Ms. Brown missing her court date when she's incompetent doesn't necessarily fall on her in the sense that this wasn't an active decision she was making. So, you know, I don't know if she'll be picked up a year or 2 years down the road where we don't really remember the fact that this program did this without consulting anybody, and that it's not necessarily her fault that she's just out on the streets right now.
Sure, that's a fair point. So Ms. Nelson, if you could send to me to wordsmith a little bit, whatever, if it's the judicial hold order, there needs to be a bench warrant in the system. And that's going to look like any other bench warrant, but there ought to be something that will go into Odyssey that would refresh our recollection if and when we catch up with Ms. Brown.
Okay, Judge.
Thank you. And that gets us to Ms. Jacobs.
I've left numerous messages for both numbers that are on Odyssey. One of them is, it just beeps at you. The other one is just a very generic voicemail. I've received no callback.
Is it, I know it's a 19 SC case, but are the underlying charges even older? Is it one of these direct indictments 3 years after the fact? I'm looking
No,
at it.
it was fairly close in time. Yeah, from October to November.
Okay. Oh, it's not, I mean, the indictment isn't even a year old yet. Okay. All right. Well, you've tried, we'll do a bench warrant for Ms. Jacobs. It does sound like this is something that could resolve if we find Ms. Jacobs. Okay, so if you learn, Ms. Snyder, that for whatever reason, Ms. Jacobs has been taken into custody, let's expedite getting her on a Zoom call or here to pursue the resolution that you and Ms. Hall have talked about. Okay, great. I think that is it for our inquiry calendar. That leaves the motion to suppress, but no one's late yet. That was scheduled for 11. But if people get here early, we can get going whenever. All right. Ms. Patel, would it help you to have Mr. Carter brought out here to talk?
It would be a better environment if Ms. Hall could step outside.
Sure. Ms. Hall, you're welcome to go to the jury room. And if we could bring Mr. Carter back out, Ms. Patel's going to speak with them real briefly. And then do you want Mr. Dunham early, or he can just come out when we start the hearing?
When we start the hearing, we can come out.
Okay, great. All right, thank you, everyone.
Judge, is your printer working?
Yeah, I just saw your thing. I don't know. Did you send something?
I did, and I got an error, so I was just making sure that that I can send things to you.
I just pressed a button on it. It's making some noises. You can try again. I gotta get out of the courtroom for a minute, so Ms. Patel can talk with, Mr. Carter, but I'll be back in a little bit.
Okay, thanks.
You're welcome to come back in chambers if you want, or wherever you want to go. I think we'll be, I don't think that, although the detective officer may have shown up, so he can be back in 5 or 10. Okay, good.
Your Honor, is there a way to mute the audio so that the Zoom individuals don't hear?
Yeah, we can do that right. All right. Is that better, Ms. Nelson?
Yes, Judge.
Thank you for flagging that. Ms. Hall, you have had a chance to review the statements. There are statements Mr. Dunham made that you would want to use in your case in chief if this went to trial?
Yes, Your Honor.
Okay, then we should proceed. So when you're ready.
Thank you, Your Honor. The court, how do you want us to stay our week? We get the last motion or you want to do this to the podium?
So wherever you can best be heard by folks on the Zoom call, although that's less critical. Mr. Dunham is here, Mr. Franklin is here, Mr. Forte is right here, and your witness will be here. So if that microphone is working, then it may be you need to take your mask off given where you're sitting, if you're comfortable doing that, so folks can hear you. But I'm fine with either location as long as you can be heard.
So, the state code officer here, lawyer, to the state, I'm sorry.
Great. Come on up, sir.
Sir, stand up for a minute. Raise your right hand. You solemnly swear and affirm that testimony about you, of course, the truth, the whole truth, nothing but the truth, so help you God? Yes, sir. State your name, spell it for the record.
Detective N. Garavalia, Garavaglia.
Thank you, Detective. Thank you for being here. Where are you currently employed?
The City of Atlanta Police Department.
And what is your position there?
I'm a detective on the gun assault unit,
And how long have you been employed with APD?
approximately 5 years.
And what are some of your duties?
Presently, my duties include the investigation of non-fatal shootings that occur within the City of Atlanta.
What was your, it was your same position on October 27, 2019?
Yes, sir.
Were you also home certified on that day?
Yes, sir.
On October 27, 2019, did the defendant Cleveland Dunham make any statements to the police?
Yes, sir.
Were those statements memorialized anywhere?
Yes, sir. And they were captured on the body cam footage of several officers, mainly Sergeant Summers, who was also of the Atlanta Police gun assault team at that time.
And have you had a chance to review this right now?
Yes, sir.
You're not cross-witness?
Yes, you may. Both sides have continuing authority to approach witnesses to present exhibits, et cetera.
Thank you. I'm having you what has been previously marked as safety exhibit 1. Do you recognize this?
Yes, ma'am.
What is it?
It is a DVD of that body cam footage that we just previously discussed.
And how do you recognize it?
My name is signed on the front of it.
And is this a fair, accurate depiction of what happened that day?
Yes, ma'am.
Your Honor, the state moves to tender in state exhibit 1.
State's Exhibit 1 is a collection of body cam recordings.
I believe it is just one body cam recording.
One body cam recording. Okay. Any objection to the admission of State's 1? Okay. It's admitted for the purposes of this hearing.
Thank you.
Can you spell Summers, Sergeant Summers, like the season?
No, sir. SOMERS.
Thank you.
And the second, was this incident happened in Wilson County?
Yes, ma'am.
And how did you encounter the defendant on that day?
I responded to the initial scene of the shooting. While at that scene, I was told by witnesses that they had gotten a tag for the vehicle that the suspect was seen fleeing in. We ran that tag on scene via the Department of Motor Vehicles records and found that the address was not terribly far away. So Sergeant Summers and I proceeded to that address to see if we could locate the vehicle. And while en route, located that vehicle parked. It was facing the wrong direction for the lane it was parked in along Oakland Drive in Zone 4, so southwest lane.
And when you encountered that vehicle, was the defendant at that vehicle at the time?
No, not at the time.
At what point did you encounter what point did the defendant come to the vehicle or did he show up at all?
I believe we were with that vehicle for approximately 5 minutes, prior to the arrival of, Mr. Dunham. The vehicle had been placed on, there had been a police lookout given on the vehicle, as it was related to a shooting. And, I was notified on radio that we located that vehicle and would take off the system because we located it. And as we're going about doing those, sort of, just like paperwork, jobs, getting ready to impound the vehicle for a forthcoming search warrant, then Mr. Cleveland Dunham arrived on scene.
Did he arrive, by himself?
No, he arrived with his wife.
And when he arrived, what did he do?
Did he arrive on foot or he drove up in yet a different car?
It was in,
Okay.
We spoke to him briefly. At some point, we started putting two and two together that he may be the suspect that we'd seen in the footage at the incident shooting location. And at that point, he was detained and Mirandized and then we questioned him further.
So I'm gonna back up just a little bit. When the defendant first walked up to his wife, was he detained at that moment?
No.
Did he make any statements at that moment?
He made a few brief statements. His wife did a good bit of the talking.
Did his wife ask him any questions?
Yes. His wife did ask him questions from the questions we asked her.
Do you remember if, any of the officers or the defendant's wife asked the defendant who was driving the vehicle?
Yes, Sergeant Summers asked if it was their vehicle. I don't remember the specifics there, no.
Do you remember if the defendant ever admitted to driving the vehicle during this time before he was detained or arrested?
I believe he did on the footage.
So I need to clarify. You were asking Ms. Hall, Detective Garibaldi, if the defendant admitted to driving the vehicle. You're referring to the vehicle parked the wrong way on Oakland that was suspected to be connected with the shooting, or the vehicle he just showed up in with his wife?
Yes, I'm sorry, Your Honor, I was referring to the suspected vehicle of
Okay.
but he admitted to driving that particular vehicle.
I believe so.
Do you know if the defendant made any other statements at that time?
Not my recollection.
Now you did mention that at some point he was detained. When he was detained, was there any further questions asked of him while he was standing there being detained?
After being Mirandized, after detaining him Mirandized and asking further questions, yeah. The majority of what we've spoken about prior to Miranda were just biographical questions, such as his name, asking for his ID, that sort of thing.
As far as the Miranda statement, who Miranda? Well, I'm sorry, was the defendant Miranda?
He was.
And who Miranda?
I did that. I Mirandized him.
And do you remember where you guys were when you Miranda?
I'm sorry?
Do you remember where you and the defendant were when you Miranda him?
Yes, we were still on Oakland. He was, I believe he was seated in the back of the patrol car, but the door was open. I read the Miranda card to him his Miranda rights to him from the Miranda card provided to me by the police department.
Did you inform the defendant on what was going on? So why you Miranda him?
Yes, I told him we were investigating a shooting.
Did you give him any details as to his involvement or his suspected involvement at that point?
Yes, during our conversation, we spoke about specifically the video from the shooting location that appeared to show an individual with uncanny resemblance to Mr. Cleveland involved in the shooting.
Did the defendant appear to understand the crime that you guys stated that you were investigating?
Yes, I believe so.
And did you read the defendant his Miranda rights from a card?
Yes, ma'am.
Did the defendant appear to understand the rights that you read to him?
He did.
What did the defendant do after you read his Miranda rights to him?
You did
And I
work.
think more specifically, did he agree to speak with, you and your fellow officers, or did he, request an attorney, or did he not want to speak at all?
I believe his words were, yeah, we can talk.
And do you know if he requested an attorney at any point?
He did not.
Did he ever refuse to talk at any point?
He didn't refuse to talk. He didn't outright say, I refuse that, I don't want to speak anymore. He just stopped really giving answers, and kind of shut down, didn't want to speak anymore. I guess, in a way, stopped talking.
But he never actually invoked his rights
No, ma'am.
to remain silent or to request an attorney present.
No, ma'am.
Just to clarify what you said that at some point he just seemed like he wasn't responding to your question or shut it down.
That's right.
Did he appear to be intoxicated at all?
No.
Were there any questions, did, you or your fellow officers ask the defendant specifically if he had been drinking or using any type of drugs?
Yes, I believe Sergeant Summers asked him if he had anything to drink that day. He told him that he had some earlier, but now he felt fine. He said he felt good. And he was able to go, we asked a number of qualifying questions just to kind of get a good gauge of where he was at mentally. He was able to tell me, you know, the number of quarters in a dollar. He would refuse to. I asked him who the current president was, and he wouldn't tell me Donald Trump, but he would tell me that the previous president had been Barack Obama. And then he described this guy as Howard Blue when I asked him what color it was.
So, in your opinion, he seems to understand everything that was going on at home.
Absolutely, he was alert, conscious, oriented, capable of understanding based on the questions I asked him. I was confident that he knew what we were asking him, knew the implications of what we were asking him, and still decided to speak those.
Did you promise the defendant anything in exchange for him agreeing to speak with you?
No,
Did you hold out to the defendant the slightest benefit of hope to get him to speak with you?
no,
Did you threaten the defendant at all to speak with you?
no, and I believe we took substantial steps to even make him more comfortable, make him remove the possibility of him feeling overwhelmed or threatened in any kind of way. There were a number of police officers on the street, and we requested that they all go away from where we were doing the interview. They proceeded further down the block, so that it was just Sergeant Summers and I speaking to him at that patrol car.
Did you hold out the remotest fear of injury, to the defendant if he spoke with you all?
No,
And what method did you use to interview the defendant? Was it conversational? Was it a formal sit down?
it was just conversational. We were on the side of the road. It was not, you know, there was no seated in a reporter room. It was just a conversational interview on the side of the road with the body cam.
Were you wearing body cam today?
I was not.
Were you in uniform today?
I was not.
Is there a reason why you either didn't have a body cam or actual uniform?
Typically, if you're not wearing a uniform, the city line doesn't require you to wear a body camera. Some officers, detectives, and supervisors over investigating units still choose to do so. I think sometimes it shuts people down to you if you wear a uniform. They're less likely to open up to you if they see you as a police officer instead of just as a, you know, detective who's trying to get to the bottom of an incident.
Do you know about how long the interview took?
I think we spoke to him for approximately 20 minutes.
Did you have to stop at all, during the interview for any reason?
Can you be more specific?
Did anything happen, maybe the wife came over and interrupted you all, another incident, had anything the defendant chose not to continue to talk, anything that would have stopped you from asking the question?
Not my recollection. I think we were still able to ask everything we wanted to ask. There may have been a brief pause here or there where the wife was speaking to us.
Did the defendant at any time retract any statements that he made?
No,
Based on the answer that the defendant gave you, did you consider the defendant's statement being freely and voluntarily given?
yes.
Your Honor, the state published state-specific one.
Yes, let me ask the detective a couple questions. You were not in uniform. Was Sergeant Summers in uniform?
I don't believe so, not that day.
But he had a body cam?
Yes.
Okay, because that somehow this got recorded.
Right, he likes to have the body cam.
Okay, and that was the means by which what we're about to see was recorded. It's not a dash cam from inside the car.
No, sir, it's the body cam.
Okay.
And once we start reviewing, you'll see the camera moves around the scene as we go about doing our work.
Thank you. So, yeah, if you hit that button, you should get the big screen there. Excellent. I think, turn this on, I'll rotate this. That may be easier for you to look at.
You could take one of the chairs and stay safe when you can step off of it.
Pardon?
Oh,
Just move the chairs so that you can see on the other side and see the video.
Oh, you can see it on this screen right here. Is it on a disc? Do you want to go to the disc tab?
it's on, it is on the CD.
If you go back into it, there was a tab.
Oh.
I don't know that, I don't know how this works. I just noticed you hit play and then see there's a tab. Yeah. Did it work earlier or we didn't?
It came up here, for me, it's just showing the phone, but earlier it did come up for the. When I had to take it out, so that I can send it in. It worked for him.
There was a refresh option in the ER. Go back to that.
Well, sometimes you click the folder thing, I mean, another thing that pops up, you can drag.
Yeah, you were clicking something and there was a refresh that may have, yeah, try that, see if you can hear whether the disc is where, I assume the disc is in the right way.
Yeah. This is working.
Do you have a copy?
I have a flash drive that has several videos.
Okay.
Just click the one.
Right back.
Can we turn this so that the detective can be seen on the feed?
Is this the disk or the flash drive? Okay.
So you're not going to play this on the.
Hold on one second.
No, I'm sorry.
Deputy asked me to turn this so that the witness was on the screen.
Great. All right, so we're gonna go back on the record. We took a break. We had some technical difficulties with State's Exhibit 1. My understanding is that a copy of that video was among the various videos that Mr. Franklin received in discovery, and he has graciously provided a flash drive, and we are playing that same video that's on State's 1, but off the flash drive. Is that what you've done, Mr. Franklin?
Yes, the video that I pulled up is the one that actually got in motion. It's the one that I anticipated being played in motion.
Okay, and it has the same still shot of someone, well, it's not quite the same, but it's the interior of a police vehicle shot from the chest of someone driving that vehicle.
Yes, sir.
All right, you were gonna explain something.
I was gonna say, I'm gonna play, two short parts of this video, and then I'm gonna play the last part. So I'm gonna play it, I'm not gonna ask any questions, I'm gonna just go through it.
It's in evidence, so you can play all of it or none of it, however you wanna do it. Detective, is the car, the tail of which we're looking at, the suspect car?
Yes.
Are you able to hear?
But don't touch the car?
Oh, well, yeah, but in general, can you hear what's going on? Because I think it's playing from here.
Yeah, it's coming out,
Okay.
all the microphone speakers.
was driving that car? Because I actually can talk about. You were driving? You were driving? Yeah, probably.
Because I went here, we went, took my mother-in-law home, and then we came back. So they are just Memorial Drive, Cadillac.
I'll be there for a while now. Yeah. What's up? Yeah, I feel you. Your wife's actually good people. I was talking to her for a while. What's that? All right, so I'm going to ask you some questions before I do that. I can read you this Miranda warning. What? What's her name? You been drinking all day? How much you drink? Huh? Like how much? Not much. Like how much you drink though? You're not worried about the lies. All right, so how do you feel right now? You smoke? Do any drugs? What do you do about it? Who was the previous president? Okay. How many dollars are you for? I'm sorry, for $1 million. Okay. Where do you live? What apartment? 416? Where do you guys sleep up? 623 is where you sleep up? Okay. Okay. What color is the sky? Is it? Sky blue. Alright, cool. Alright, so I'm ready to see real quick. Number one, you have the right to remain silent. Number two, anything you say will be used in court as evidence against you. Number three, you're entitled to have a lawyer now, have a present now, or at any time of your question. 4, if you cannot afford a lawyer, one will be appointed for you without cost, and you may be present at all times during your question. Number 5, you use the silence at any time to exercise your rights and not answer any questions or make any statements. Now, these rights of mine, do you still wish, do you understand these rights? With those in mind, do you still wish to speak with me at this time of that lawyer? Okay. All right, so right now, Where you saw this one go? Where about? Where do you like to hang out? Way out for, this is way out for. Okay. Very good. What's that? Sir, go right back, okay? Just give us a second. Hey, guys. Yeah, get search warrant. We get photograph here if you want. There's great money in front of our. Okay, appreciate it. Fine, then we'll go. We don't get started. Speak up. Speak up. We're saying you're talking about it. All right. You have any idea why you're in right now? Sorry. Don't. So, your car was seen, it didn't seem an aggravated assault, they shot you. What we just did was a gunshot rescue, that's not me. That's gonna come back in about 2 weeks, and tell us if there's gunshot rescue present. That's I don't think it's a matter of law. There's a video outside the wing store of a person who prepared striking with someone's to you, shooting a lady in the leg. Is that? Yeah. Is there anything you can tell me about that? Okay. Let me ask you this. Have you driven your car all day? over there and you have a pothole somewhere between there and here. Where you up there, what happened? I'm shooting curve. Where specifically on Cascade? Is there a specific store that you're hanging out of? Okay. Cool. Before we get a search warrant, go to the car, then also go through your mother's house and your wife's house, your house. Is there any houses on that area? The Malibu? Is that? Okay. So you're saying not to your dog? Is there a dog in the car? So you're saying that you had the car, you were saying you were getting out of that car. Someone said they opened up and changed the tires until now you press the brake and then you're leaving. Were you up by the office? Happy birthday, by the way. I heard it on the 25th, right? Your wife's the 26th? So you were there today? Okay. Because I saw the picture on your wife's phone, and the picture literally right there at the office. Around your birthday and stuff? You got a side chick on there? We know about the mirror. So we know about the mirror. Is there some beef between like his parents and that? What do they call you? What do people call you, Coach? What's the name? Yo. So, if you remember, can you tell me what do they call you up there, the office?
So can we pause for a sec? What I need to work through in the analysis is not, can I hear what Mr. Dunham is saying when cars roll by, or is he admitting or not admitting? Really, the essence is, were his statements that we're hearing now freely and voluntarily given following a meaningful administration of the Miranda rights. We've passed that already. And so I'm pausing this only because unless there's something that's about to happen that you think would influence the analysis, like Mr. Dunham says, I'd like a lawyer now. And the sergeant and the detective say, no, you have to keep answering our questions. I don't know that we need to play anymore right now. It's hard to hear what Mr. Dunham is saying. You're free to keep playing, but this seems to be more what a jury would be trying to hear during the trial than what I need to listen to work through the pretty discrete legal question that you've largely answered through the testimony already. Certainly, Mr. Franklin is going to get to cross-examine the detective to highlight what his concerns are about the administration of the Miranda rights. and their possible waiver. Is there more you think we ought to work through that gets to those questions, freely and voluntarily given, and they understand his rights and meaningfully waived?
No, Your Honor, the ending part was just as we take the testify to, it just kind of leveling out, so, frankly, I feel like enough has been shown. I just,
Okay.
if we got there, I was gonna allow you to see it, but it's not necessary.
I'm good, and I'm certainly not precluding Mr. Franklin from moving to a different section where there is something that he thinks is noteworthy. So the discrete question we've got right now, but I think that'll be more efficient if we do that.
That's fine.
Okay.
I'm just gonna minimize this, so it's
Sure.
an issue.
Okay.
Detective, the person that, you questioned on October 27th, 2019, is he in the courtroom today?
Yes, ma'am.
Can you identify him by letting the court know where he's sitting and, also, he's wearing?
He's wearing the blue overshirt with the white undershirt, sitting over there next to the public defender.
Your for the record, can the record reflect that the detective that identified as defendant?
He did do so, yes.
And there's no further questions at this time.
Okay. Mr. Franklin, do you have questions for Detective Carvalho?
Yes, sir. Detective Gary Potter, I said it correct, right?
Yes, sir.
Okay. So one thing I'm gonna do, I typically don't do, but because it's COVID, I wanna be sure. I can barely see your face. So you don't take your mask off, but as I was watching the video, I noticed that we're looking from the body cam of one person. And we're looking at another person's hair and facial features and such. Which one are you?
I'm it's not up anymore. I think I'm actually wearing the same shirt in the video. I had hair, and I had beard, glasses.
Yes. So you're the person, you got hair a year ago.
I had hair.
A year ago today, actually.
Yeah,
Yes.
we're on the 1 year anniversary, but the gentleman with the glasses who said, "Hey, Sarge, from here," that's you. Okay.
Okay. And I just wanted to make sure that I couldn't pick up the voice indicators and be sure that that was you. Okay. So as I understand, you received information that was a shooting at this shopping center, correct?
Correct.
You had an opportunity to go to that shopping center first.
Correct.
You were able to observe for yourself with your own eyes surveillance footage.
Correct.
And you received information from another officer about a description, a photo description of the person they believe may have done the shooting.
Correct. And through what I observed in the footage.
Okay. So this is the information that you kind of have within your realm of now developing knowledge when you go search for the car.
Correct.
Okay. And you eventually locate the car on Oakland Drive, Oakland Terrace, something like that.
I believe it was Oakland Drive.
It's not important which one. You located the car when we saw it in the video, right?
Correct.
And so you and Detective Summers had been at the car just a few minutes, looking at the license plate and looking at the condition of the car before the Dunnams approach you, right?
Correct.
And when the Dunnams approach the car, you tell them both not to touch the car, correct?
Sergeant Summers told me that, yeah, but yes, they were about to touch the car.
Because they were instructed not to touch the car.
That's correct.
Okay, so if they want to leave the car, they cannot leave at that point in time.
No, the car was part of our investigation at that point and would be something we didn't want people touching.
And as we also saw in the video, once they kind of get up to the car, you all realize that they are the owners of the vehicle. You ask if they own it, or you were Detective Summers asked if they own it.
Yes.
And you asked for Mr. Dunn's ID.
We got his and his wife's ideas.
Okay. Which specifically turned to ask him for his particular ID at that point, right?
Yeah.
Okay. He was not free to leave at that point in time.
He asked for his ID back at that point, I would have given it back to him, he would have left. They arrived in a different car.
So your assertion is that the person who you earlier testified to had an uncanny resemblance to the person in the video who was wearing a clothing that matched that which you had received the description of, whose ID you had requested, who you had confirmed was the owner of the car, At that point in time, he was free to go.
I mean, at the point we were still investigating.
Okay. And you investigated with both of them standing there, and you asked kind of what happens to the car, right? How did the car get into the condition?
I believe Sergeant Summers asked how it happened, and asked that of Mr. Dunn's wife, if I remember correctly.
Okay. He asked specifically of the wife, or he just asked the question?
I think he just asked the question, and the wife answered.
Okay. So he asked the question, the wife answered, and the wife then kind of follows up with Cleveland, right?
Right.
Okay.
And it was hard for me to tell from the video footage, what was wrong visibly with the car? Was it the rear bumper? There's a description, Summers used some pretty colorful language describing how the car looked, but I didn't see anything. What could you see?
Both of the wheels of the passenger side, one was like cracked, like the actual rim was broken, and then the wheel was flat, and on the back, I believe it was dented, and the wheel was flat.
So it wasn't body work, it was wheel/tire.
Wheel/tire.
Okay.
So that kind of addresses the first half video the first portion of the video that Ms. Hall went over with you. I'm going to move on to the second portion, where Mr. Dunn is already been cuffed and he's been waiting in the car for a while. Okay. Do you recall how long the time period has been since he had been placed in handcuffs and sat in the vehicle?
I don't know.
Okay.
I'm sure if we need to, we can pull the video back up and get those exact times.
Four, if you cannot afford a lawyer, one will be appointed for you. Where do you guys see that? 6 months.
Okay, so we're approximately the 126 mark, give or take a few seconds. This is about where you begin to ask to administer or Detective Summers or yourself begin to administer the Miranda, correct?
Correct.
That's a minute 26 or so.
All right, you're registered number PU50.
We called them a few minutes ago and told them where I went.
I said, just move for weapons.
Okay, and we see at about the 11:06, but a few seconds before that, you all actually placed in handcuffs, correct?
Correct.
So 11 minutes, minute 26, so a little over an hour.
Correct.
And how long you've been sitting in the car waiting to figure out what's going on, right?
Correct.
So you all do something that's, kind of, I want to make sure I understand. You all read Mr. Donovan's Miranda rights, yes?
Yes.
And then you swab his hands.
Correct.
You don't ask for his consent to swab his hands, right?
No.
Okay, you got told him like, after you read him the Miranda warnings, which are for making statements, you then tell him that somebody's going to come and swab your hands because there's been a shooting.
Correct.
This is the first time that you tell Mr. Donovan what the purpose of his detention is at this point, right?
No, looks like it.
And who has more experience, yourself or Detective Summers? Who's been working?
Sergeant Summers.
Sergeant Summers?
Yes, sir.
And Sergeant Summers is the person who inquires with Mr. Donovan whether or not he's intoxicated at that point in time, right?
Correct.
And Mr. Donovan says that he's had something to drink that day.
Correct.
I couldn't hear very well from the audio. Is it clear how much he drank that day?
He said he had, I believe his terminology was a couple earlier, or some earlier. But he also advised that he felt that he was good to drive and to talk.
Okay. So he said he had a couple of drinks. We're not sure if that's beer. We're not sure if that's malt liquor. We're not sure if that's alcohol, hard alcohol. a couple of something, right?
Correct.
And he says, but I'm good to drive.
Yes.
And that was sufficient for you to be comfortable with him waiving the constitutional right.
No, that's why we asked further questions to see what his level of orientation was.
Okay. And so your questions were, if I remember correctly, what color is the sky?
Yes.
And you asked how many quarters are in a dollar.
Yes.
And you asked, what was the other question? Who was the president? Who was the president? And he says, I don't want to say the name, right?
Correct. It was asked who the previous president was.
Okay. So he says he doesn't want to say the name. What's your interpretation of that statement?
I thought he probably wasn't a fan of Donald Trump and did not want to say that.
Did you consider the possibility that he couldn't recall the name, which is why he didn't want to say it and get it wrong?
He was able to accurately name the previous president, which you would have to recall something from further back than even the most recent president.
Okay. Is it not possible that a black man just not remember the name of a black president more quickly than he might be able to access the name of Donald Trump?
I don't think that would have any bearing on it, really, no.
But to resolve these things, you decide, the other questions are, how many quarters in a dollar and what color is the sky?
Yes, which he was able to answer very specifically the color of the sky is being comparable to.
If, theoretically, before you were a detective, were you ever a patrol officer?
Yes.
Did you ever stop people for DUI?
Occasionally, yes.
Okay, so had the person you suspected was drunk or intoxicated or otherwise affected said, I had a couple beers earlier, I'm good to drive, there are 4 quarters in a dollar, you would let that person get back out on the street? No, just that information alone, that's sufficient for you to be satisfied that person's not intoxicated?
No, I mean, there's other questions and other tests you perform.
Okay. At this point in time, as we can see from that portion of the video, Mr. Dunham is in custody, sitting in the car, right?
Yes.
It's possible for you to just hold off and interview him later when he's either had a chance to dry out or when you are more certain that he's not under the influence of alcohol, correct?
Yes.
Okay, but you instead chose to go ahead with the questioning at that point in time.
Yes, because we felt that he was adequately sober enough to be able to speak to us at that time.
Understood. One final thing, kind of going back to the first question, I think it kind of addresses the entire situation. When the Dunhams had approached you all, as you all were inspecting the car, they asked what was going on, right? And you all chose to not be honest at that point in time and tell them that, you know, we're investigating this big thing.
That's correct.
You told them that, I'm sorry, it's,
The vehicle was facing the wrong way in the car almost hit it, yes.
why was black?
Because at that time, when he arrived on the scene, our wheels began turning, or I guess to speak for myself, my wheels began turning. This is possibly the person that I just observed in that video. And at that point, officer safety was my concern. This person's not detained. We haven't located a firearm. If he's just walking back up now, he may still be armed. I didn't want to, I wanted to eliminate the possibility of him knowing that we were actively investigating the shooting and that it should just be happenstance that we came across this car there.
Thank you.
Ms. Hall, any follow-up with Detective Garbalia?
Just one or two questions, Your Honor. Detective, defense counsel asked you a lot about DUI and whether the defendant was how his appearance was. Did he ever, was he able to walk on the ground?
Yes.
Did you ever hear him slur his words?
No.
Did he appear to being intoxicated and not being able to understand what was going on.
He did not, there was conversation when they arrived, it was clear and concise, just as you are shooting.
Was there times when the defendant was detained in either your patrol car or your partner, Sergeant Summers' patrol car, where you or either Mr. Summers, Officer Summers were talking about what you guys were investigating?
Yes, he was advised at that point in the car while we were investigating.
And when the Dunhams walked up and you guys were asking, you and your and Sergeant Summers were asking for their identification, as you said earlier, he was not detained at that point.
No,
And at that point, were you radio and getting further information on the investigation of the shooting that happened prior to you encountering?
you're asking if I was,
Still actively investigating the case.
yes, ma'am.
At that moment when you guys were just getting the defendant and his wife's information, was he free?
Yes.
Thank you, no, sir.
All right. Do you have any other witness? Maybe the detective step down?
Yes, Your Honor, and no further witness.
Thank you, sir. Appreciate it. Mr. Franklin, any evidence?
No, sir.
All right, well, the evidence is closed in connection with the motion to suppress Mr. Dunham's statements to Sergeant Summers and investigator Garvalia at the scene of his arrest and not down at the station house. Do you want to make any argument beyond what I've understood your argument to be, Ms. Hall? I'm happy to hear from you.
Yeah.
Okay. Mr. Franklin, anything more than the record that's been made?
Yes, please.
Okay.
It's very brief. So I will address it in two parts. First things first. I think that the contention that Mr. Dunham was not detained for the purposes of the initial question is approaching the space in a very elementary understanding, in that we oftentimes in court see people think you're not detained until you actually have handcuffs. I think the cornerstone of the analysis is more directly related to whether or not the officer has exercised control or authority over a person such that they reasonably would expect that they're not able to come and go as they please, not whether within the officer's mind, whether he subjectively is okay with them leaving or not. I do believe that subjectively, we know that he wasn't able to actually walk away at that point in time. The officer acknowledged that at the moment he walked up, this is one of the last questions I asked, he realized this might be a person who was a suspect in the case, which is the reason for the questioning. He had seen the video. In his opinion, the person in the video had an uncanny correlation. He looked like Mr. Dunham. He had received a description, a clothing description that he acknowledged felt fit what Mr. Dunham had been wearing. A person who looks like the person who you're looking for under any circumstance involving an officer of the law who you've already exercised authority over by telling them not to touch the car, objectively, is not someone who's going to be able to walk away, or more importantly, somebody who's going to feel that they're going to be walking away after an officer told them, you can't go to your car.
So a couple questions. One, was it your understanding that the vehicle everyone was interested in was even operable? It sounds like there was a flat tire and two bashed up rims. Because one scenario you explored was, well, could Mr. Dunham have gotten in the car you told him not to touch and driven away? The answer wasn't he couldn't leave. It was he came in a car, he could have left in the car. I know you disagree with that, but you've been focused on what we'll call the suspect car. Does it matter that he couldn't have left in the suspect car since he had just shown up in a car?
It doesn't matter with that particular car. I think the exercise of authority, exercise over the car, translates to a person, okay, you're an officer, you're checking out the stuff in my car, and I can't even touch it.
Second question is, let's say I agree with you, what's the consequence of that? That if Mr. Dunham was not free to leave, I'll say as soon as he handed his license over, a marker, it may have been a few seconds before that, but if he wasn't free to leave as soon as he handed his ID over, how does that change what I'm working through here.
At the point in time, we're gonna, if you were to acknowledge that at this moment, we establish, you can detain, then at that point, the questions that are asked are solely questions, and you're not being Mirandized.
So anything he said that was sort of non-biographical, anything he responded to that was a non-biographical question from law enforcement, not from his wife, would have been investigative, but post-detention.
Correct.
Okay.
And I believe that the question wasn't submitted just to the wife, the question is asking y'all, so who's driving the car? Were you driving the car? Yada, yada, yada. Like, it's a question for everybody, it wasn't something that was just focused on, so the fact that she kind of pivots, because she doesn't know the answer, all right, baby, well, what's the answer? It's a question that was intended for both of them. They would have told Mr. Donaldson, don't answer that question, I'm talking to the lawyers. That would not be the response of any officer in that situation, right?
Okay. And how would you suss out, Mr. Dunham's wife isn't detaining Mr. Dunham, and she's not law enforcement. So if she turns to him and asks a question, and he answers it, what's the law enforcement action? I appreciate they may have asked her a question, but she then asked Mr. Dunham the question. How is that?
And I think legally speaking, I'm not sure there is any basis for asserting that another civilian is detaining another civilian. Now, the question is she's the person that's questioning. Again, she only says, babe, what do you think about that? Or something like that. I may be getting it wrong verbatim, but she doesn't come up with a novel, original question of her own. She pivots, like, well, I don't know, you know? She's only required for more information that had already been asked of both.
Great.
As it pertains to, so that's essentially what that analysis comes down to, is the one question of how the tire did damage, that kind of thing. And the response at that point in time was a pothole kind of thing. So that's kind of the extent of the question for that portion of stuff. When we get to where he's been sitting in the car for an hour, 5 hours, 10 minutes, and then the officers Mirandizing. They were Mirandizing a situation that doesn't really apply to what a Miranda would be. They decide they want to get a gunshot into the squad room. And they say, you know, we're gonna read you this, we want you to get swabbed up. They don't ask for consent, that's a different matter in terms of the gunshot into the squad. They then begin to get in Miranda, and the other officer, as best as I can gather the video, picks up on something, right? Which is why he gets into this involved question about being intoxicated. If we watch just like Mr. Donald's body language as they walk up and all about this video, I think it's noteworthy that once we learn that he's been drinking and you look at it through the scope of that he has a relaxed such demeanor that may suggest that he may have had alcohol very recently. Not quite understanding this, but it's kind of oddly disinterested thing, which may also explain why he's not as forthcoming with officers at that point in time. So there's something that tickles Detective Summers to make sure that the person is not intoxicated at that point in time. And so that's an actual legitimate concern. You have someone who is definitely under your authority at this point in time, who you can take to a precinct and interrogate later if need be, because there's no requirement that they finish the charges right now. We know for a fact they actually continue to interview them later on. The question is, how do you resolve this question about his intoxication? And they ask him questions that my 4-year-old can answer. And my 4-year-old is not smart enough to waive a constitutional right. So whether Mr. Dunham in that condition could understand the circumstances that he was facing, understand the implications that came with it, are not satisfied by questions of what color is the sky, how many quarters are in a dollar. And the one question that he showed some difficulty with answering is the one about who's the current president, whose name he either didn't remember at that point in time, or who, from the officer's perspective, could have honestly just like, I don't like the guy, I'm not saying his name. We don't know because that part wasn't required upon further, but we do know that he was unable to answer that question.
We know he didn't answer it. Whether he was unable or unwilling is what you and Ms. Hall are arguing about.
So,
What would a question be that would meet your test? I don't know that every 4-year-old would be able to answer how many quarters in a dollar or who the president is. They might say Washington. They might say Trump. I don't know. But what in your mind would be a fair test for lucidity at the time of an interview, if there was a concern, and even if there's not a concern?
I honestly haven't considered that question, but off the top of my head, I think just informing like we're asking about very serious set of circumstances, and it's important that you are clear about what the circumstances are, that there are consequences for them. So, being that you had a few drinks today, would you feel comfortable talking about it now, or would you have a chance to kind of sober up a bit, because you're taking into custody? That's a fair, honest, neutral way of making sure that somebody is sober enough to understand the stakes of what they're being asked.
Okay. What are you doing with the GSR swab? Because you've talked about, it's not clear he consented. That's not in your motion, which doesn't preclude you from making any argument you want. This may be the first you learned about the specific circumstances, but I don't want to issue an order and have unintentionally ignored a claim that you're making. I know at least two things you're arguing. One, any answers given to questioning basically after the Dunham showed up until he's Miranda should be excluded because he was effectively detained upon showing up. I get that argument. And the second one is really anything asked after Miranda should be excluded as well because it wasn't, I'll have to figure out what the,
Sufficient.
yeah, what the adjective is. It wasn't a knowing waiver or an informed waiver because your contention is he was intoxicated.
Yes, sir.
And so I can work through both those. There'll be case law that can help me with both those. I just don't want to leave I don't know that the law requires a warrant to swab someone's hands, just like they can roll your prints when you get booked in. They don't need a warrant for that. So I don't know where we are.
Likely a motion to immunity. I wasn't sure if it was a motion to suppress area myself. So,
Okay.
it's certainly something I would plan to address the motion to immunity.
Okay. I may look at it and if the case law that I find suggests that no warrant is required to do or consent is required to do GSR if someone's in custody, if I drop a footnote to that effect, doesn't mean you can't bring it up as a motion to eliminate if this is going to trial. I just don't want to leave it hanging now that you flagged it. Okay. Anything else you want to argue?
Not this time.
All right. Ms. Hall, anything you want to say in response? I know that you think Mr. Dunham, was not detained when he first got there, and you rely on the detective's testimony to that effect. And then you've covered why you think the Miranda waiver was valid because of either what we saw on the video in terms of Mr. Dunham's apparent sobriety or his answers to the questions that you highlighted. Anything you want to add?
I just would add a note that, if you remember when you watched the body cam, that Mr. Dunham was able to move around freely before he was ever put into handcuffs. He even went to the very side of the car and observed the damages himself. No one ever told him to come back, stay in the spot, don't move. They didn't question where he was going. So in my opinion, In my mind, I mean, I'm sorry, in his mind, he could have walked away. They were investigating the car that was reported in this incident, not that person at that time, because they didn't know who he was. So I just want to add that note because that was shown very clearly in the body cam multiple times. He was moving around without being stopped. So other than that, no.
Technical question, exhibit 1 is in evidence now. I'm gonna hold on to it. It will ultimately go to Mr. Forte. Will I be able to play it, or do I need that funny cone, piece of software?
I was able to play it on the regular computer upstairs. These computers in the courtroom, you have to play through the home.
Yeah.
So I believe when you get back there, you can play on your
Okay.
computer.
Gotcha.
If not, just let me know, I can make you another copy.
Okay. I'll have Ms. Nelson let everyone know, and then we'll figure out a plan. All right, so Mr. Dunn, here's what's next. I need to take this under advisement. Your lawyer has made some good arguments about concerns he has about what we just watched and what you went through 1 year ago today. I need to enter an order. Once I've done that, Mr. Franklin, is this case trial ready, or is there more? I'm not aware of other motions who've dealt with the discovery issues. Anything else?
Not that I can really think of at this time. I don't know, like, I would have to research everything.
I'm not holding you to it, but nothing jumps out at you like, well, no, then we need to have this other.
There's no other big motion, we address the state stuff.
Okay, well, good. Well, then that's it. I'll get the order out and we will go from there. Thank you, Detective, for giving us some of your time. And then you all are gonna stay for a little bit,
Yeah.
so Mr. Dunham can watch something.
Yes.
Great. All right, I'm gonna get out of here. Deputy, do you mind? What's your ballpark estimate for how long it will be, so I can see if they're okay?
15, 20.
You good with that? Okay, thanks. We're done with all the inmates. Thank you so much.
And you don't have a afternoon calendar?
No, we're done. Tomorrow's drug court. I'll be long.
I'm actually, sit up in the office.
Okay.
This is my job.
How you doing?
Is this this? Is this the this? Thank you. I had the same question. He looked totally different from the guy with glasses.
Yeah.
And hair.
I was trying to pick up on the voice.
I thought that was funny because he said Summers had body cam, so I figured he must be the other guy.
But it changed a bit on, like, if he was the one who's actually wearing my kid that he can die.
Yeah.
You're asking the question versus the other person.
Thank you, Ms. Nelson. I think we're all done.
Thank you, Judge. I do have one question. Did Jacob show?
No. So we've got